Hello students, welcome to Drishti IAS. My name is Saloni Nankyoliar and in today's session we are going to study the 4 labor codes that have been introduced by the Government of India. Amalgamating 29 central laws, the Government of India has come up with 4 new labor codes from 29 central laws that used to exist on labor, because labor is a subject of the concurrent list, which means that both the central government as well as the state governments can make laws on labor. That is why we used to have 29 central laws and then certain state laws. Now all these 29 central laws have been amalgamated into 4 labor codes or 4 labor laws, because it is important to bring about uniformity or reduce the ambiguity in all these laws that used to exist. So these labor codes are going to have a set of laws which are going to benefit both the employers as well as the employees, because the goal here is to serve both. The goal here is to bring about ease of doing business. Ease of doing business is going to help our employers. Ease of doing business plus the ease of working conditions, easing out the working conditions for our employees. So when you study the provisions of all these labor codes, you'll realize that they have been designed in a manner that they're going to help both the employers as well as the employees. And to bring about uniformity in the implementation of the entire labor laws, we have amalgamated these 29 central laws to 4 labor codes. And these 4 labor codes are: first is the Code on Wages. We will discuss all these codes in detail, but for now let us write them down. First is the Code on Wages. Then we have the Industrial Relations Code. Code on Wages, Industrial Relations Code, Social Security Code. And lastly, we have the OSH Code. OSH, Occupational Safety, Health and Working Conditions Code. So all these codes are going to benefit employers as well as employees based on the different provisions that they have. So let's start with the first one, that is the Code on Wages. So what is happening in the Code of Wages? The most important thing that has come up is that a single unified definition for wages has been provided for all purposes. So as I told you that labor is a subject of the concurrent list. Both the central government as well as the state governments could make laws on this, and because of this different states used to have different definition of wages, and that is why it became difficult for various calculation purposes. And for now in this Code on Wages, a single definition of wages has been defined, and wages are going to include your base pay plus the durance allowance plus the retention allowance. And this was necessary to bring about uniformity in the calculation which require wages. If different states are going to have different definitions of wages, then the calculation is going to be difficult and it is not going to be uniform. That is why it was very important to come up with one single unified definition of wages, and that is what we did in Code on Wages. Then a national floor wage has been introduced. So national floor wage has been introduced by the central government. And based on this, based on the floor wage, the states have to come up with minimum wages. So the minimum wages cannot be below the national floor wage. They'll have to be equivalent or above the national floor wage, which is going to be introduced by the central government, and minimum wages will be introduced by the state government. So this also gets very important, because declaring these wages basically motivates people to join the employment force. And earlier this used to happen only for scheduled employment. Scheduled employment basically was a list of all the sectors, all the industries that were listed by the government, they came under the scheduled employment. But now minimum wages will have to be defined, will have to be declared for all the types of industries, all sectors. So irrespective of the industry, irrespective of the sector, irrespective of the gender, irrespective of everything, minimum wages will have to be defined. So they have been universalized. Earlier they used to exist only for scheduled employment. Now they are going to exist for all types of employment. To bring about more transparent and fair implementation process, they are now going to be implemented across all the industries, across all the sectors. Then a timely payment of wages has to be ensured to all employees, and overtime wages have also been defined that they cannot be less than twice of the normal rate. They'll have to be at least twice the normal rate. And the deduction also, deduction in wages can also not increase 50% of the total pay. So all these provisions are going to help the employees ensure their wages so that they can plan their finances accordingly. They can be in a more stable and secure position when it comes to wages. So all these things have come under the Code on Wages. Next we have the Social Security Code. Now here the most important thing that has come up is the definition for gig and platform workers has been introduced legally for the very first time. So we know that the unorganized sector, the gig platform workers, were suffering a lot because they were not under the umbrella, they were not covered in the umbrella of Social Security. And now because we have defined the gig workers, the platform workers legally for the first time, they will also be covered in the Social Security bracket. In fact, a Social Security fund for the unorganized and gig workers is stipulated. So the central government will also contribute, the state governments will also contribute, and the aggregators, these platforms will also contribute to the Social Security Fund, which is being stipulated for the unorganized sector. So this is a big achievement over here, that the unorganized sector, the gig platform workers, have also been introduced. They have been defined, and that is why they can be covered in the Social Security bracket. Then fixed term workers have become eligible for gratuity after 1 year. First of all, what do you understand by fixed term workers? So fixed term workers are the workers whose term of contract, whose term of employment has been defined. The duration of employment has been defined. It is fixed term. So it's usually a short term employment, mostly seasonal in nature, 1 year, 2 year, 3 year contract. So these fixed term workers have also now become equivalent to permanent workers, in the sense that they are now eligible for gratuity after 1 year. Earlier this threshold used to be 5 years for fixed term workers, and now they have become equivalent to permanent workers in the sense that they also become eligible for gratuity after 1 year. So fixed term workers become eligible for gratuity. Then the EPFO coverage has also extended to all establishments having 20 or more employees, and ESIC cover has also become mandatory. Even a single person is engaged in hazardous occupation. Presently this number is 10. This threshold is 10. So 10 people have to be engaged in hazardous occupation for the ESIC cover to be implemented. Now even if a single person is working in hazardous conditions, the ESIC cover will have to be extended. So more and more social security is going to be provided to the people who work in the unorganized sectors, to the people who work on these gig platforms, to the people who work in hazardous occupations. So this again is going to benefit our employees. Okay. Then we have the Industrial Relations Code. Now in the Industrial Relations Code, worker has been defined. Again, to bring about uniformity, to reduce the ambiguity, worker has been defined. Who is going to be called a worker has been defined, because different states used to have different definitions. So for implementation purposes, worker has been defined in the Industrial Relations Code. Then threshold for layoff and closures has been raised. Now this is a point of contention, because earlier what used to happen, if factories, they used to have employees, 100 plus employees, then if there was a layoff, if there was any retention or retraction, in that case a government approval was needed for 100 plus employees. Now this threshold has been increased to 300 employees. So this is going to make what? Hiring and firing easier for these factories. So this is being raised as a point of contention over here. This is a controversy that now hiring and firing, the layoff can be easier for these factories because the employee threshold has increased. Earlier it was 100 plus, now this is 300 employees. Then strikes and negotiating union rule has also come in. Now strikes, earlier for any strike to take place, a notice of 6 weeks had to be given, and now this also has raised to 60 days or 2 months. So earlier notice was 6 weeks was enough, but now a notice of 60 days will have to be given prior to any strike. And even mass absence or mass leave have also been included in the definition of strike. So when you study the detailed definition of strike in these provision, mass absence or mass absence of all these workers, mass leave of all these workers has also been included in the strikes definition. And then the negotiating union rule is there, that there will be only one negotiating union with 51% of worker participation. That is going to be the sole negotiating union. Then what about the negotiating unions who do not have this amount of participation? So for them, negotiating councils will be created and appropriate representation will be taken. So this again is not going to benefit a lot of small negotiating unions that we have, because now the representation has to be 51%. So there is going to be a sole negotiating union. And then the introduction of fixed term employment has happened, which I already told you that fixed term employment has been introduced, and these fixed term employees are equivalent to permanent employees in the sense that they are eligible for gratuity after 1 year. But the problem here, there can be a flip side to this thing. Now, if the employers are able to get people on fixed term contract, they might not feel motivated enough to hire them on a permanent basis. And the employees might also feel that they are being covered in the social security bracket, so it's okay to go on a fixed term employment. So this can be a double-edged sword, where you are introducing fixed term employment, but it should not be equated to permanent employment in all sense, so that the employers also identify that there's a differentiation, employees also identify that there's a differentiation. While this should also be introduced, but at the same time, this should not be only this shouldn't be the sole way of engaging with an organization. Permanent employment should also be there, and fixed term employment should also be there, but permanent one should also be there. So this is happening in the Industrial Relations Code. Then we have the Occupational Safety, Health and Working Conditions Code, which is the OSH Code. Here, now there is a single registration, common licenses and electronic filings for our companies. So this is going to benefit our employees. It is going to ease out the registration process. It is going to ease out the license process. Then women are also allowed night shifts. This is also an important change that has been introduced, that women will be allowed night shifts provided that they give their consent and the safety conditions are ensured. Safety conditions by the employers are ensured and the women also willingly give their consent, then they can be allowed to work in the night shift conditions. Then fixed working hours have been defined. Fixed working hours, 8 to 12 hours per day. It shouldn't exceed 8 to 12 hours per day. So fixed working hours have also been defined for the proper living working conditions of all our employees. Then mandatory health checkups have to be provided by the employers. Now this can also be a challenge for employers who have very limited number of people, who are small organizations. They'll also have to provide these mandatory health checkups. So this can feel like an additional burden at times to small establishments. So this is a flip side, but largely this is a good thing that's happening, that a mandatory health checkup for the employees will have to be mandated by the employers. Then the definition of interstate migrant workers has been expanded, because here self-registered workers will also be included. Then a safety committee has to be created. A safety committee has to be created for factories where 500 plus employees are working. Then construction units, if 250 plus employees are working, and mines, if 100 plus employees are working. So if the hazardous situations increase, the dangerous situations of working are increasing, the danger levels are increasing, so the number of people that are required, the threshold of people is decreasing. So a safety committee has to be created for factories with 500 plus employees, construction units with 250 plus employees, and mines with 100 plus employees, so as to ensure the safety of employees. Then mandatory appointment letter, salary slips to each employee have to be provided. Many a times this does not happen. Small institutions, they do not provide mandatory appointment letters. They do not provide regular pay slips, and this becomes a challenge for the employees whenever they switch their jobs, or even for their own social security purposes when they have to prove their employment. So these things become a challenge. So a mandatory appointment letter, salary slips to each employee will have to be provided. So largely these are the provisions of all the 4 labor codes, and I'm sure you would have been able to acknowledge that largely they're going to benefit the employees, but they're also going to benefit the employers. They're going to ease out their registration process, their licensing process, and if there's anything that these employees or the employers they feel that it's not working appropriately, there's a violation of these codes, then they can reach out to the inspector cum facilitator, who is going to listen to the grievances and then act appropriately. So all these labor codes, they have been introduced to ease out everything, to include the ease of doing business as well as include the ease of living conditions or working conditions for these employees. So this is what's happening largely in all these codes, and that was all for this video. I hope you were able to understand the different provisions that we discussed over here. Now let us practice a question for prelims. With reference to the 4 labor codes recently introduced in India, consider the following statements. 1. The Code on Wages introduces a single national floor wage and applies minimum wage to all workers across sectors. 2. The Industrial Relations Code raises the threshold for prior government permission for layoffs and retrenchment from 100 workers to 300 workers. 3. The Social Security Code provides for the first time legal recognition of gig and platform workers. 4. The Occupational Safety, Health and Working Conditions Code allows women to work night shifts subject to safety provisions and their consent. Which of the statements given above is or are correct? So please note down the options over here. A. 1 and 2 only. B. 1, 2 and 3 only. C. 2, 2, 3 and 4 only. And D. 1, 2, 3 and 4. A. 1 and 2 only, B. 1, 2 and 3 only, C. 2, 3 and 4 only, or D. 1, 2, 3 and 4. So please read all these statements carefully and comment down your answers, and we'll meet in the new video. Thank you for watching.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.